Hello, everyone, and welcome to CLRNN Conversations. Today, we're in conversation with Professor Paul Idornigie, SAN. Professor Idornigie, SAN is an award-winning scholar, senior advocate of Nigeria, and law reformer who has contributed considerably to the development of the Nigerian commercial law. Professor Idornigie, SAN, has lectured at various colleges and universities in Nigeria, including, notably, the University of Jos and the Nigerian Law School, Abuja. He held the SMA Belgore Distinguished Chair as a Professor of Law at the Nigerian Institute of Advanced Legal Studies, Abuja. At the Institute, he also held several other roles. He was the head of Department of Commercial Law and Alternative Dispute Resolution. He was Director of Research and Director General. He has taught and published extensively in local and international journals on ADR processes, company law, company secretarial practice, public finance, constitutional law, international economic law, investment law, investor state dispute resolution, law reform, and private sector participation in infrastructure delivery. As you can see, that's a whole suite of subjects on which he has lectured and written. Professor Idornigie, SAN, was also previously General Counsel and Head of Secretariat at the Bureau of Public Enterprises, BPE, in Abuja. In that role, he was involved in the first draft of the Petroleum Industry Bill in 2005, between 2005 and 2008, which has just passed recently. He was also involved in the unbundling of the National Electric Power Authority, NEPA, into the initial holding company, that's the Power Holding Company of Nigeria, PLC, and subsequent transfers to generation, transmission, and distribution companies. Also, the privatization of LMA Petrochemical Limited, Transcorp Hilton Hotel, the concession and lease of the port terminals in Lagos, Warri, Port Harcourt, and Calabar, amongst other public enterprises. Professor Idornigie, SAN, continues to practice in both commercial and investment treaty arbitration, either as counsel or arbitrator. Out of the 5 production sharing contracts that the Nigerian National Petroleum Corporation, NNPC, executed with the international oil companies in 1993 that resulted in arbitration, he was involved in 2 of them as a party-appointed arbitrator. Similarly, he was a counsel in the International Center for the Settlement of Investment Disputes arbitration involving the Federal Republic of Nigeria and Shell Nigeria Ultra Deep Limited, the OPL 245 Malibu dispute. Sir, you're welcome to CLRNN Conversations.
Thank you very much, Bolanle.
Yes, sir.
It's nice having this conversation with you. Thank you.
Oh, it is our honor and our delight to have you with us today.
Yeah.
In the first of our series of conversations with Professor Idornigie, SAN, we invite him to give us insights into the black box of commercial law reform in Nigeria. And for this, we will use the recent reforms to the Companies and Allied Matters Act 2020 as our entry point. Prof, many people may be unaware of the events that led to the reform of CAMA 2020. You led a comprehensive review of the institutional, regulatory, legislative, and associate instruments affecting businesses in Nigeria report, which was published as a final report in January 2016. Could you give us the background to that report?
Yes, thank you very much. It was, for me, a very, very challenging exercise. We were appointed by Adam Smith International and carried out a study on behalf of the 8th National Assembly. I must say here that Dr. Bukola Saraki, His Excellency, as the President of Senate, was very, very interested in law reform. And the 8th National Assembly did a lot in this area. So we were sponsored by DFID, and you know DFID has all kinds of programs, like the one they call James, they call Enable 2, James 3. Then we published a final report that was reviewed by the Nigerian Economic Summit Group and MBA section on business law. Now, this report was validated by an economic impact assessment. Would you like to know why the study was carried out?
Yes, sir, that would be very interesting.
I'm sure many of us are aware of this World Bank doing business that has been on since 2005. Now, Nigeria has not fared badly in the ranking. In fact, in 2008, Nigeria was scored very low. Nigeria was 114 out of 183 countries. But by 2015, Nigeria was 170. And when we were carrying out our study in 2016, by the 2015 report, Nigeria was 169 out of 189 countries. Now, the National Assembly did not like the ranking of Nigeria in this doing business report, and they felt that there was a need to examine why we are scoring that low. Before our study in Nigeria, I'm not aware that there has been any study that really examined why we are ranking that low. Now, what does doing business do? What they do really is they gauge the relative ease or difficulty of opening or running a micro, small, and medium enterprise. Now, there was a need for us to carry out an assessment to know what do they look for? What do they look for? The study looks at 11 regulators, and they score every country on those 11 regulators to arrive at the overall scoring. But like I said, the National Assembly was not happy at all about our ranking, and they felt that something will be done in the hope that we will have a better enabling business environment, leading to increase and sustain private sector participation. The assignment had 6 components. The first one was for us to carry out a diagnostic review of current and proposed laws relevant to business environment in Nigeria and make recommendations on those laws. We were also directed to look at the existing laws, the bills in the National Assembly, and look at whether there are gaps in them that needed to be filled. We were also supposed to determine whether the laws that we had compared favorably with laws in other jurisdictions. And like I said, because the study, the doing business has to do with the micro, small, and medium enterprises, we will have to determine whether there were laws in Nigeria that were barriers or impediments to the development of these micro, small, and medium enterprises, and make recommendations. That was our mandate. And I led a team of 4 researchers to carry out this study. Would you like to know the other members other than myself?
That would be great. That would have been my next question. Yes. Sir.
Okay. Now, other than myself as a team leader, I had Leonard Ugbaja. I also had Eberechi May Oko and Azaya Bozimo, who is now the Honorable Attorney General and Commissioner for Justice for Delta State. So I'll stop there.
Okay. Thank you very much, sir. Well, I think that there are 2 questions that I would ask following this.
Okay.
And the first would be, so you mentioned that there were other countries that you compared us with. And I was wondering if you could give us some examples of that. And then if you could just briefly summarize, because we'll still get into this during the interview, what the key findings of your report was.
What the World Bank does is to categorize countries into regions, like Sub-Saharan Africa. So our focus was looking at developing countries, especially in Sub-Saharan Africa. That was our focus, to see why Nigeria was scoring that low. Our score really was very embarrassing to some of us. And as you go on in this our conversation, you'll find what we did and what the government of Nigeria is still doing now to ensure that indeed we have been improved considerably in the doing business of 2020. We now score 131 out of about 190 countries. So our work produced some desired results. Now, what we did, we reviewed all the laws in Nigeria that have to do with the business environment. We didn't stop there. We also look at the bills that we are pending in the National Assembly on this area, i.e. bills dealing with the business environment. On the whole, we reviewed 54 acts of parliament and 48 bills that were pending as at 7 January 2016. Now, our key findings. The first one was that we decided to ascertain how the ranking was done. We found that the ranking is done essentially based on regulatory processes, procedures, and practices, not necessarily laws. For instance, if you want to incorporate a company, what are the procedures? What are the steps? What are the costs? So these are things that they measure. Want to start a company? Yes. What are the steps that you take? The timeline, the costs. These are things that they cut across all the regulators. Now, the World Bank report of 2016 gave a guideline. And if I must quote from their report, it goes thus, and I quote, "For policy makers try to improve their economy's regulatory environment for business, a good place to start is to find out how it compares with the regulatory environment in other countries, and also see how useful it is to know how it ranks relative to comparator economies and relative to regional average." Now, in our final report, we showed how Nigeria stood in relation to comparator economies. So for Nigeria to improve on our ranking, we needed states like Lagos and Kano to cooperate. What we found is that generally in every country, the World Bank picked a commercial town. But for big countries like Nigeria, they picked 2 towns. They didn't pick Abuja, so they picked Lagos and Kano. So all this ranking we'll be having over the years is based on their studies from just two states. I was thinking that they were carrying out a national study, then they found an average. No, it depends on the practices in Kano and the practices in Lagos. And you can say Nigeria, you can see the sharp contrast with what you will find in Lagos and what you find in Kano in terms of regulatory environment. Now, we also find that in the area of taxes, for instance, in Lagos State, they had a minimum of 18 taxes to comply with. I mean, we are talking about startups, we are talking about small companies, we are talking about micro, medium, small enterprises.
So right at the start of their lives, they had 18 taxes.
A lot. Even in corporation, a lot. So that is why our ranking was very, very low. So we now said, look, we need to revisit all these processes. Now, we also found that there were several bills. For instance, competition. There were 2 bills on competition in the House of Representatives, and another bill on competition in the Senate. You know, the members of the Assembly are anxious to sponsor bills, and they will not care that there's a bill by somebody else in the National Assembly. So we wonder why there were 2 bills on competition in the House of Rep and a bill on competition in Senate. Meanwhile, there will be need to harmonize this bill to have one bill that will go to the president. When I joined BP in 2002, my first involvement was on the Federal Competition. Well, when we started, it was called Federal Competition Commission Bill. That's how we started. Then, in the course of drafting, we found that the Consumer Protection Bill was impinging on what we are doing. We then merged them. So that's how we now have Federal Competition and Consumer Protection Commission Bill. Now, I have been involved in this bill in 2003. It was passed into law in 2018 and accepted to in 2019. So, as I will show later, for me, is one of the achievements that can be recorded in our favor in terms of what we did. Now, we also find that in the area of acquiring land for businesses, the Land Use Act was an impediment. In terms of getting the governor's consent. And you know, the main collateral we have in Nigeria is just landed property. So we said there's a need to streamline the procedure for obtaining the consent. Now, we found several gaps in the existing laws and the bill, including the Constitution, and we stated them in our report, the gaps that we found. Now, I talked about the Federal Competition Law. Now, we also found that between the bills in the House of Rep and in the Senate, there was no coordination. You find one subject matter, 3 bills in the House of Rep, 3 bills in Senate. So now I said there's a need for a clearing house that before a bill is introduced for a first reading, there's a need to clear this bill to ascertain whether there's a similar bill in the House, to see what is in Senate. I agree that Section 58 of the Constitution says that a bill can start from any of the houses. It can start from the House of Reps, it can start from Senate. But I would prefer that it's the same bill that starts in the 2 houses. What we have at the moment is we have one bill in Senate, we have one bill in the House of Reps, that they will look at them, review them separately until it comes to harmonization. For me, harmonization becomes very, very difficult if the bills are different. Harmonization is easier if the legislators are looking at the same bill. So we recommend that there should be a clearing house so that before a bill is introduced to the House, this House will clear it. These are our main findings at the beginning of the exercise. Thank you.
Thank you very much, sir. And that's really interesting. And it leads me to, the next set of questions. This has been one of the, I think, key issues that has disturbed myself and colleagues when discussing law reform in Nigeria. Yeah. We have all found that there's usually a multiplicity of laws and a multiplicity of agencies working on the same or connected issues without a clear delineation of powers across these institutions. Now, could you take us through, some of the
such bills and laws? Yeah, I will start with the Public Procurement Act.
Okay.
This act was passed in 2007, and the act is concerned with the procurement of works, goods, and services. Procurement of works, goods, and services. In 2005, we had the Infrastructure Concession Regulatory Commission Act. And this act is concerned with the concession of infrastructure. The issue is, when the Infrastructure Concession Regulatory Commission is trying to enter into a concession, for instance, the railway. Is that transaction within the purview of the public procurement? And in other words, there's a Bureau of Public Procurement established under the provisions of the Public Procurement Act. Now, the Bureau should set threshold who does what in terms of procurement. Now, like I said, the issue is when the ICRC, they are trying to concession the railway, does the Bureau of Public Procurement have a role to play? Is the concession of a railway, does it fall within the definition of works, goods, and services? If you bear in mind that in a concession, all the government is doing is just granting a right for a private sector entity to carry out a function, either to carry out by government. So if you say, like, I use the railway, get a concessionaire who will agree to take our railway for a period of 4 years, reconstruct them, and after 4 years, start paying us a concession fee. Is that a transaction within the purview of the Bureau of Public Procurement? That's an issue that has not been resolved. My position is there's no work, there's no goods, there's no service. Maybe at the point of procurement of transaction advisors, if you're going to procure a transaction advisor for the PPP transaction, then the procurement of a transaction advisor can go to the Bureau of Public Procurement. But the transaction itself, drafting of the concession does not require the prior review of. That's my position. That is one conflict. Another conflict is the Public Enterprises Privatization and Commercialization Act. Many people don't know the name of this act. They just call it, many people have called me, they're looking for Privatization Act. I say you won't find it. There's no act referred to as such, but the real name is Public Enterprises Privatization and Commercialization Act. That act was passed in 1999 to carry out essentially privatization and commercialization. Then, like I said earlier, in 2005, the RCLRC was also packed. What will you find interesting? The Privatization Act has about 4 schedules. The first 2 schedules is a listing of public enterprises that are for partial privatization. The second schedule is a listing of public enterprises listed for full privatization. Then you have a similar thing for commercialization. That's why we have 4 schedules in the law. Now, by the time the Infrastructure Concession Regulatory Commission Act was passed in 2005, the enterprises listed under the Privatization Act are listed in the ICRC Act as infrastructure. For instance, so you find railway in railway listed as a public enterprise, railway listed as infrastructure. So since 2008, there has been a fight between BPE and ICRC. Now, ICRC will argue that BPE is to carry out privatization and commercialization and not concession. BPE will argue, ICRC, your full names are Infrastructure Concession Regulatory Commission. You are not a regulator properly so called, because the infrastructure referred to, the railway, the roads, they have their regulator, like power sector. In the power sector, we have the Nigeria Electricity Regulatory Commission. In the telecom sector, we have NTC. So ICRC, you are not a regulator properly so called. Now, to determine what you can do, look at your functions in your law. Your function says that you will take custody of concession agreement and monitor them. It's not for you to do transactions. BP will say, no, BP say, look, it's for us to do the transaction that the word privatization has ordinary meaning and has a broad meaning. That don't see it in terms of sale and purchase of assets. No. Privatization can also mean concession. So it's we in PPE that have a right to carry out prioritization, commercialization. But you, when we finish, we'll give you the agreement to monitor. As we speak, that bill, that issue is still not resolved. When I was in BPE, when we realized this problem, we drafted a bill to merge the two. BPE is a parastatal that is headed by the vice president, and the vice president chairs the National Council on Privatization. Our bill got there, but Alhaji Yaradua was the president then. When our bill got to Mr. President, he said BPE and SCLC can coexist. And I tell you, as I speak, they are not coexisting properly. There are issues. So I hope at some point there'll be a clear definition as to who does what. But at the moment, there's no clear definition as to who does what. There's also a problem with the Nigeria Ports Authority. It functions conflicts with that of Nigerian Inland Waterways. Now, I also find a particular section in the Inland Waterways Act very interesting. In section 13, it prohibits persons from taking sand, gravel, or stone from the waterways without the consent of the authority. If you are used to this environment, this is the livelihood of the people around the river areas. And we are talking about growing the micro, medium, and small scale enterprises. So we think that that act needs to be amended. If you even look at the Nigerian Railway Corporation Act, that act in section 25 provides that no authority can carry out railway activities in Nigeria without the consent of the Nigerian Railway Commission. In other words, no state as of today, no state. That law was passed in 1955 and is still there. No state in Nigeria today can start a railway service without the consent of the Nigeria Railway Commission, and we are a federation. That is why some of us are arguing that move railway from the exclusive list to the concurrent list. Now, the CAMA has a provision for multiple directorship. We felt that it should be pegged. I would recommend that it should be pegged at 5. I'll come to this later, but you find that CAMA 2020 is actually pegged. It gives me joy that it was part of our recommendation. Now, CAMA 1990 is section 3551 defines a small company. The definition provides that a small company should exclude an alien. We say, no, that cannot be correct, because if you look at section 17 and 18 of the NIPC Act, that Act provides that there can be a company in Nigeria since 1995 that is only owned by aliens. So you cannot say in CAMA that the definition of a small company is a company without aliens. And unfortunately for us, I found that the exact provisions in CAMA 1990 that we protested against were just lifted and put in CAMA 2020. So we have 2 laws saying that you cannot do this in one, the other you can do it. Then we also found that in Nigeria, although there's a bill on corporate social responsibility, in the UK, that is whatever in the UK Companies Act. So we believe that we recommended that in the reformed CAMA, there should be a provision on corporate social responsibility. So the duties of, we're talking about this, the difference between stakeholder theory and shareholder theory. In other words, does the company exist for the interest of the shareholders only or the stakeholders? I believe the stakeholder theory. So we recommended that there should be a provision to empower the environment, the public, the creditors, instead of shareholders to benefit from the company. And I think I'll stop here for now. Thank you. I hope I'm not looking. I hope I'm not talking. How much time do we have?
No, it's fine. We have an hour for the conversation.
All right, okay.
It's very interesting. No, you've raised a lot of really pertinent issues. And like I said, one of the issues that we are concerned with is this competition between regulatory agencies, so-called in Nigeria, and a lack of hierarchy or a hierarchical distribution of powers, or some complement between them, deciding who is what and how to work together.
Do you know that until the Federal Competition and Consumer Protection Bill was passed into law, almost every regulator had a chapter on consumer protection.
Yes.
So if you look at the NCC Act, Next Act, you find that they have sections on consumer protection. But these have all been repealed. In fact, even on the issue of monopoly, because there was no central law, the Investment and Securities Act was handling the issue of mergers and acquisitions. We believe that mergers and acquisitions should not be, because the ISA, Investment and Security Act, is for the security sector. So you cannot regulate the power sector, cannot regulate the communication sector. But all these have different provisions. But since the passage of the Federal Competition and Consumer Protection Law, there's no such conflict again. Is this law that handles the issues of consumer protection? Thank you.
Yeah, thank you, sir. Now, it's really interesting, and you've touched on various areas that CLRNN works on. We have one of our editors who works on consumer protection and distinguishing between competition, consumer protection, and she has talked about some of the complexities of the Nigerian consumer protection legal landscape. We also have those, interestingly, we have a series called the CLRNN Spotlight Series on corporate governance and insolvency law in Africa, where in one of our upcoming presentations, an early career researcher will be looking at the coexistence of CSR and corporate governance within the Nigerian company law framework, and she has taken a comparative view of these theories. And there she's talking about, well, I guess each person talks about whether they propose stakeholder the approach or whether they propose the shareholder wealth maximization.
Yes. Well, corporate social responsibility is a subset within corporate governance. There are many definitions of how to consider a company. There's some people talk about agency theory, all kinds of, I have a book that deals with all kinds of theories. But for me, again, because I've been involved with company law since 1983, I can follow the trajectory. The original position was, to whom does the company owe a duty? That's how we started. To whom does a company owe a duty? Very from the duty is to the shareholders only. That's how we started. Then increasingly, we added the company, the members of the company. Then we're now looking at the environment, that the company operates within an environment. It should cater about the community. And so for me, it's a gradual process. So we should look at what point in Israel we're talking about. So company law is evolving. It's evolving. I have moved from the shareholder theory to stakeholder theory. I believe that if you are a company operating in an environment, you should provide for the environment. That is why today you find companies like in Nigeria providing schools, providing medical facilities, providing electricity facilities, providing roads. It's not their primary responsibility, but because they operate in an environment, there's what we call the social license to operate. Social license to operate. So the environment should validate you.
Yes.
And see you as part of them. Thank you.
Yeah. Thank you, sir. And like I said, these are interesting topics to which we will return at various points in the future. I just want to explore CAMA 2020 a bit more, because that's I think that's been a very interesting piece of legislation, and I don't want to reveal my age, but I think that we grew up together, CAMA and I. So it holds a very special place in my life. Well, the report says, your report says that MSMEs are responsible for over 84% of the employment in Nigeria. That's a lot.
That's
and
massive.
you also, that's a lot. It also outlines the challenges that entrepreneurs face. Could you tell us the links between the report and CAMA 2020? What were some of the key changes that you saw between the old framework and the 2020 framework?
Yeah. Like I said, I've been around in the company law. I first qualified as a chartered secretary in 1986. I'm not sure we are. That's when I qualified, and I did company law in the UK. So I've been into company law since then. Now, my position has always been that in a place like Nigeria, where Section 18 of CAMA 1990 says, from the commencement of this law, you must have at least 2 shareholders. I asked myself, because I used to do corporation when I was younger in the business. Now, a corporation in Nigeria is generally one person. And I found instances where the person will put the son's name or the wife's name without their knowledge. I've seen a where somebody will put a friend's name without the person's knowledge. I'll give you my particular experience. My son incorporated a company. After a corporation, he came to tell me that I was a shareholder in his company. I said, how did you get about doing this? He said, no, they just, his friend who's a lawyer did everything for him, and he just put my name, and that was it. He then came that we should open an account. I said, no problem. He had drafted the resolution and said there was a general meeting. I said, but we are just 2 shareholders. When was the meeting held? He said the meeting has been held. And what is the resolution? That we should open a bank account and he will be the sole signatory. What am I trying to say? What we have in practice has been one-man company. So when we are writing that report, I said, look, we should be deceiving ourselves with a minimum of 2. It's one person. And this kind of, you must have a general meeting, none is held. They just draft a resolution. So I'm glad that if you look at the new section 18, sub 2, it now provides for a single shareholder and a single director. I'm very excited about that. Now, if you look at section 27 on the issue of a share capital, CAMA 1990 provides for authorized share capital. We recommended in our report that worldwide, there's been a movement from authorized share capital to minimum share capital. And that in some jurisdictions, either they have reduced the minimum share capital or they've eliminated it completely. So we recommended that it should either be eliminated or reduced. But I am not happy that in the same section 27, what we now have there is minimum paid up capital. Minimum paid up capital. And if you recast your knowledge of company law, CAMA 1990 says there should be authorized share capital of 10,000 naira, out of which 25% should be taken. Okay? So assuming you take that minimum of 10,000 naira, at the corporation, you are only asked to take 25%. Now, CAMA 2020 says the minimum paid up capital is 100,000 naira. The consequence is it's paid up. The consequence is at a corporation you must pay the 100,000. We're talking about startups. We're talking about micro. Where will they get the 100,000 naira to pay before a corporation? So I'm still arguing that we need to revisit this section because the focus today is on startups. If I did a presentation 2 weeks ago on startups, if you want to encourage the startups, the micro, the mini companies, they cannot afford. Now, if you look at CAMA 1968, there's no minimum share capital at all. It was argued that shareholders abused it, they were incorporating, it protects creditors. I ask myself, if you do a job with a company and the company is paying you 5 million naira, all right, will you be looking at 100,000 naira in case of default? So what you ask myself, investors, creditors, banks, what do they look at? Is it your turnover? Is it your net asset value or the share capital? I think that serious investors will be interested in your turnover or net asset value and not. That is why in some jurisdictions, they eliminate it completely or make it as low as possible. I think that 100,000 naira is still too high for small investors. Now, there's also the question of statement of compliance. You'll find that in section 40 sub 1. You remember CAMA 1990? You see, they're taking business from us now as lawyers. In the past, a lawyer must sign that statement of compliance to enable startups. That has been abolished. You don't need a lawyer to sign that for you. Then the issue of common sale, section 98 has made that optional. It's no more a compulsory requirement. Now, to transfer, the instrument of transfer, that can be done electronically now under section 1761. Now, small companies under section 241 can now hold their general meetings outside Nigeria. Again, like I said, it's one person. One person. Why are you saying that it must be held in Nigeria? Just one person. And the same thing, small companies can now hold their general meetings electronically, insofar as it complies with the provisions in the Articles of Association. Again, like I keep saying, it's one person. But I like section 265 sub 6. You know, it's only in the Code of Corporate Governance that there's provision on whether, as a chairman, you can be a CEO. It's now codified. Under section 3656 of CAMA, for a public company, you cannot be a chairman and a CEO. Then, the issue of independent directors, again, before now, it's only in codes that you can find it. Section 2751 now provides for 3. In fact, most of the codes, they provide for 1 independent. So there are just for some of us who want to be players in the corporate world. So there's provision for independent directors for public companies. Now, I talk about the issue of multiple directorship. We were against it. We recommended 5. And if you look at section 3071, if you go to this section, I was looking for CAMA yesterday. But in my CAMA, I didn't have 3071. So under section 3071 of CAMA, for public companies, you cannot be a director of more than 5. Now, the issue of appointing auditors, I always ask myself, one-man business, what do you ask for detailed accounts? How much does it make? So for a small company, you need not have auditors now. Also secretaries. If you look at section 330, you need not, it's not compulsory to have a secretary now. Then on the issue of insolvency, for me, that's a major issue in CAMA.
Can we discuss insolvency a bit later?
Okay, fine. Okay.
Yes.
Okay. All right. I will just end this section by saying that under section 861 of CAMA, certified true copies can be filed electronically. I stop here for now. Thank you.
All right. Thank you. Thank you, sir. Well, so that's interesting to hear the list of things that has changed to your delight. Were there other things? So you've mentioned the issue of authorized share capital and minimum paid up capital. Were there any other proposals that you thought would be great to include but were omitted in CAMA 2020?
Yes, other the minimum pay capital that I think should be eliminated. There's also the issue of corporate social responsibilities. Okay. It's in UK Companies Act, and I think that we should. Like I said, there's a bill on corporate social responsibility that has been going up and down. You know, you hear that a bill has gone through first reading, and that may be the end of the bill. So there's a bill working on that, but I think like what the UK did, it should be in, because we're looking at duties of directors. So I think that corporate social responsibility should be one of the duties of director in a company enactment, not any other enactment. So I would love to see the issue of CSR dealt with there. I also talk about the issue of definition of small company. I think that section should be revisited because it's in conflict with the provisions of the NIPC Act. I think those are the things that
Okay.
I would like
Thank
to
you.
see in the revised CAMA.
Yeah, I think SMEDAN also provides its own definition of small companies,
I
which
know.
is one
Micro,
that,
yes,
yes,
in terms of a number, 10 members, 5 million. Yeah,
yes.
I know.
So
I know.
these are, yes, these are real challenges that we have.
Yeah.
So so I'll go back to the journey of CAMA 2020.
Yeah.
We know that there was a 2018 CAMA bill that was passed by the Houses of Assembly, but it was not assented to by the president, and it then returned, and we then had a different version of CAMA come out. Do you have any insights as to what happened to that 2018 bill and why it was returned?
You know, we live in a very funny country. You can hear that a bill has been passed or the bill has been accepted to. We can't get a copy. I must confess that this CAMA 2019, I tried, I couldn't get it. You find in Abuja, it's the hawkers that says bills to us. And so you can have different versions of the same bill. So I think that the government should have a place. We have government press in Nigeria like you have in other jurisdictions that should, as soon as a bill is passed, it should be gazetted so that we can go and pick a copy. But today, you hear a so I heard about this bill, but like I said, I couldn't get a copy of it.
Okay.
So what I do now, like I said earlier, you see, bills are introduced. You hear first reading. That's the end of the matter. You hear anything again about the bill. So by the time the bill goes through, I'll give you an example of the CLRNN Act. I was in BPE, we were in BPE when that law was passed. We didn't know. We didn't know. Look about 2005. I was general counsel BPE. We didn't know that there was any such bill. Because if we knew, we would have attended the public hearing to say, look, what you are defined as infrastructure is already in our bill. Until it was passed, we didn't know. So I didn't see this bill, I must confess. Okay. So I don't know what was there. Yeah.
Okay. And I'll also, carry on with this theme. So when in 1990, two eminent professors of company law in Nigeria, Professor Akoki and Professor Roger, with whom you have worked, or with whom you worked before his passing, they described CAMA 1990 as progressive company law reform. They were quite, they commended the process that led to that, the enactment of that act. And interestingly, this was an act that started off as a decree, so it was passed during the military era. The CAMA, the decree that was passed was accompanied by a report, an annotated report that helped us understand what the changes were that were being made, why those changes were being introduced, and that helps with the interpretation of the changes to the law. I want to understand whether you think CAMA 2020 has followed in this progressive company law reform ethos that was described in 1990, and any ideas as to whether there was an annotated report accompanying CAMA 2020, or if there's any interpretative aid that we might look to out there?
Yes. You know, I used to teach company law at the law school, so I'm very fond of, in fact, they were calling me CAMA when I was at the law school, because I think I knew substantially all the sections of CAMA then. Now I'm law school 2020. Now, prior to CAMA 1990, we had Companies Act 1968. Now, Companies Act 1968, like in other jurisdictions, was operated with common law and equitable principles. So what we did with CAMA was to codify these principles. And in its codification, I will never forget cases like Solomon and Solomon. I will not forget Ashbridge Railway Carriage Company and Ritchie. I will not forget Royal British Band and Torquay. I will also not forget the role in Fort and Harborton. All these are codified in 1990. So you'll find them in sections 39, 38, 39, 69, really 299. 299 deals with the role it fought and how to. So for me, it was unprecedented. And in fact, Nigeria became a leading country in terms of codification of company enactment. Like I said before, then it was just one skeletal law, then common law and equitable. Like if you still look at duties of directors, they are still largely between the common law principles and equitable principles. So I appreciate how CAMA 1990 came into being. Now, CAMA, like you rightly observed, CAMA 1990 is a product of the Nigeria Law Reform Commission, established under the provisions of the Nigeria Law Reform Act. That act is a statutory body that is empowered to codify and simplify laws. So Orojo was there. No, it was first Sir Stanley Alexandra, that was the chairman of the Law Reform Commission. He started the process that I think he died somewhere along the line, and Orojo took over. So in 1998, they produced a report on the reform of company law in Nigeria. They also produced the draft decree, like you said, it was a decree. But it was a military government, but the job was done by the Nigeria Law Reform Commission. And if you go and check the composition of that commission at that time, it had our best scholars, our best lawyers in the area of company law. So that's what happened, and that led to CAMA 1990. After 1990, the Law Reform Commission has been organizing workshops as part of the statutory mandate on the reform of company law and the raised areas that needed reform. Indeed, in writing our report, we had to refer to the various reports produced by the Law Reform Commission. But because CAMA 2020 is not a product of the Law Reform Commission, it's a product of many representations made to the national. The main driver first was CAC. CAC sent a draft to the National Assembly. The National Assembly organized public hearings. And so inputs were made by various organs. A committee was set up that was referred to, I'll talk about NASBA. I've not talked about, I talk about NASBA at the beginning. Now, NASBA pioneered setting up of a technical advisory committee to work with the National Assembly. So by 2017, what you refer to now as the 2018 bill, that 2018 bill was submitted to the technical committee for review. So we have today the report of the technical committee on the reform of company law. We do not have a report like the Law Reform Commission report of 1998. And we do not have a draft bill from this technical committee because, like I said, the National Assembly already had a draft from the CAC. So what you have is a technical committee. So instead of, like what happened with CAMA 1990, the committee just look at areas that they think should be tampered with, areas they were not happy about. And I think that the committee, to a large extent, implemented our recommendations. So there's not today annotated company law. It's a major challenge. It's a major challenge to researchers because we would like to know, for instance, why they abolished authorized capital. We'd like to know. They should tell us why they pegged number of directors to 5. They should tell us. But unfortunately, we don't have any such thing. Thank you.
Okay, thank you, sir. Okay, so I would take it, we're about to round up the interview now. I'll just ask what you were going into it before, what your thoughts on the insolvency law, the insolvency ambit of the law reform was, and then I'll take your final comments after.
Okay. I know that the provisions of CAMA 1990 were highly in favor of creditors. If you look at the provisions on receiver manager, depending on how the debenture was drafted, a debenture can authorize a debenture holder to appoint a receiver manager to go in there, they cover my money and pay me. Then, if you look at the winding up provisions in CAMA, I mean, CAMA 1990, one of the grounds for winding up of the court is when a company cannot pay its debt, inability to pay debt. And how much was the money? 2,000 naira. So you find that largely CAMA 1990 was meant to protect creditors, and not necessarily. That takes us back to this stakeholder theory. Are creditors the only persons interested in the welfare of a company? No, there are workers, there are shareholders. So it was thought that CAMA 1990 was too pro litigation and pro creditors and pro winding up. The focus was, if you cannot pay, we'll just wind you up. And you know, companies can be in difficulties for various reasons. Now, it could be temporary, it could be permanent. So if a company cannot pay 2,000 naira and you file a petition for winding up, or you appoint a receiver, that may be the end of the company. So we now say, okay, let's plan for a rescue mission. Let's see whether, instead of winding up, we can appoint, say, an administrator. Say, within 1 year, run this company. One major difference between an arbitrator and the receiver is that an administrator runs the company in the interest of the company as a whole. A receiver, in fact, CAMA provides that if you appoint a receiver, it's your agent. So a receiver, who is your agent, goes in there to realize the whatever is owed to the debenture holder. So we have moved. We moved in CAMA 2020 to a rescue mission where if a company is distressed, the first point of call is not receiver manager or winding up, but it can go to call an office of voluntary arrangement. I like that as well. Voluntary arrangement where you can call a creditor and say to him, we owe you 1 million. Can we pay you 20 and you forgo the balance? Instead of filing a petition to wind us up, or appoint an administrator, like I said, to run the affairs of the business in the interest of the company as a whole and not move towards winding up. So for me, this is the major innovation in CAMA, the provision of voluntary arrangement and the provision on the appointment of administrators.
Okay. Thank you very much, sir. So we'll round off the conversation today. It's been a very interesting conversation where you've told us about some of the changes that your committee suggested, and you talked about having this clearing house where bills could go through and you could merge bills together or give some feedback. Well, I would like to know whether, one, how that is being carried out, and whether, you know, in the 4 years that has passed, the various other recommendations that you made, how they have been incorporated into the Nigerian law, commercial law reform process.
Yeah, well, like I said, the 8th Assembly was pro-reform. It was really interested in reform. It's this 9th Assembly, I don't know what they are doing really. For me, I just like to close my eyes and put them one day and realize that this 9th Assembly, the tenure is over because I already know what they're doing. 8th Assembly was pro-reform. Now, let me tell you one thing wrong with executive bills. If executive bills are introduced to a particular legislature and they are not passed, that is the end of their status as being executive. So unless they are reintroduced by the president as executive bills, members will be scrambling for them. For instance, in our report, you will find what we refer to as the reform bills. Reform bills. These are bills that I was involved in drafting when I was in BPE. For instance, the Post and Abos bill, the Nigerian Railway Corporation bill, the Newer bill, Postal Commission bill, Rules bill. These bills, I left BP 2009. These bills were drafted before 2008. They are still in National Assembly. I call them orphans because they came as executive bills. They were not passed in the years they were introduced, so they are just floating. So unless the executive reintroduces them. Anyway, what we did in our report is to categorize bills. There are some we refer to as high, some medium, as low, in terms of priority. So we said the National Assembly should give priorities to the high bills and ensure that they are passed into law immediately. Now, as we were submitting our report, NASBA was incorporated. NASBA was incorporated and started working with the National Assembly. Now, so from where we stopped, NASBA took over. NASBA has been driving our report since 2016. And I am a member of the NASBA Advisory Council. In fact, we're meeting again by end of this month. The last meeting, I said to them, I said, look, I am tired of looking at railway bills. The Port and Abos bill was drafted in 2003. When we are going to reform the port, because as we were drafting the bills, we're also reforming the sector. So preparatory to leasing out the ports in Lagos, Calabar, and Port Harcourt, we said, look, the Nigeria Ports Authority cannot be the owner, a regulator, a service provider. We must unbundle it. So we provided for an independent regulator in the bill that we drafted in 2003. That bill has not been passed into law in 2005 within the concession of the port. Now, when we were BPE, the Shippers Council tried to play the role of a regulator. We said, no, you can't be a regulator. You can't be. But when we left, they made Shippers Council. I see how today that Shippers Council cannot be a regulator, cannot be a, in regulation, you draw a line between technical regulation and economic regulation. Shippers Council cannot play technical regulation to the NPA. That is what you find ourselves. But I say to you, NASBA is following up on all our reports, all of them. All the bills are still listed for passage into law.
All right. Thank you very much, sir. And this has been a very enlightening conversation. I'd like to thank you for all that you have contributed to the reform of commercial law in Nigeria, and also for assisting those of us who are researchers in this space to better understand the landscape of commercial law reform in Nigeria. We will be back for more conversations with you, and we're really looking forward to those conversations. Thank you very much, Professor Idornigie.
Bolale, let me thank you for making me to review what I've done from 2002 till date. I know that we'll have a section on BPE separately, but I have been involved in law reform in Nigeria since I joined BPE 2002. I sent you a document. Many people know BPE as an agency for sale of enterprises, but I think we have done more in the area of law reform. The Pensions Reform Act was drafted by BPE. The NCC Act 2003, BPE was part of it. The Electric Power Sector Reform Act 2005, I was involved in that. The Civil Aviation Act 2006, I was involved in that. The Minerals and Mining Authorities Bill, so BPE as General Counsel, my shadow cuts across all sectors of the economy. But nobody remembers all this. Like the reform bills I keep talking about. Can you imagine if we now have a reform bill on the port sector that provides that the NPA will just be a regulator? Can you imagine if we have a bill on the postal sector that separates our international obligations to ordinary postal service? The ordinary postal service, the courier companies in Nigeria are taking it over. Now, can you imagine when we have a proper law for the Nigerian inland waterways that will allow the people in the environment to do their normal fishing. Will you think about a law? We have a bill of Nigeria Roads Bill that will be a regulator for the road. Well, there's a law, Nigeria Road Funds, that will provide. So all the bills, there were about 7 or 8 bills that we drafted then. Only the Federal Competition Commission bill has been passed into law. I am not happy about it, but so what you have done to me is to give me cause to revisit this, and more importantly, our work we did for the National Assembly on business environment. For me, is a major contribution to the growth of commercial law in Nigeria. And so for you to conceptualize having this conversation with me, I'm also thank you too, because you're giving me cause to look at what I've done, what I've not done, and now think about what I need to do. Like I said, my joy is I'm a council member of NASBA. So I'm still involved in the drafting of this bill. I will continue to ask questions about these bills that were recommended, that are seen in National Assembly, those that are offered, those that are not offered. You know what happened in National Assembly? A bill has to have a driver. So if it's a government bill, no driver. No driver. So you find that the private members' bill, they tend to move faster than the public bill. So although people argue with me, a public bill, unless you do something, it may not be passed. But the private members' bill, they are facilitated and they pass them. So we need as a country to have an assembly like the 8th Assembly that was pro-reform. Bolale, thank you very much.
Thank you very much, sir.